So we're talking about the 1972 case, Branzburg v. Hayes. And what does the 1972 Branzburg v. Hayes consist of? Well, 1972 Branzburg v. Hayes was a landmark decision by the Supreme Court of the United States, herein called SCOTUS, invalidating the use of the First Amendment as a defense for reporters summoned to testify before a grand jury. Branzburg v. Hayes says that the government's job of investigating crimes outweighs the First Amendment privilege of the freedom of the press, because its task is to inquire into the existence of possible criminal conduct and to return only well-founded indictments. Its investigative powers are necessarily broad. Why do we have a grand jury? Well, there's actually a dual purpose to the grand jury, but one of them is to issue indictments, to figure out indictments, information, indictments. There's something about information, well, to inquire. So you got to figure out what the damn thing is, right? So you get all these people in a room, a bunch of citizens, and you say, hey, you guys, have y'all seen any damn crimes? And then eventually from that conversation, they'll say, yes, we've seen crimes or we've heard of crimes. And since they either seen the crimes themselves, well, that would go to a presentment. That's a presentment, or an indictment when you have enough evidence to say that there's probable cause that a felony, specifically felonies, because of the Fifth Amendment. The case, Branzburg v. Hayes, was argued February 23rd, 1972, and is decided June 29th of the same year. So it takes 4 months after the argument for a decision to be made. You argued it February and then decided it in June? My God, SCOTUS should never be married, am I right? The reporters lost their case by a vote of 5-4. This case is cited for the rule that in federal courts a reporter may not generally avoid testifying in a criminal grand jury, and is one of the few cases where the U.S. Supreme Court considered the use of reporters' privilege. Do we have freedom of the press in America? Well, apparently, according to Branzburg v. Hayes, 1972, no, we do not have freedom of the press. We have the freedom to say this and to say that, but if we are talking about a crime that we had observed, they could pull us into court and ask us everything that we know about the possible crime, and especially a grand jury. The case was argued, in 1972, the reporters lost their case 5-4. Paul Branzburg of the Louisville Courier-Journal, in the course of his reporting duties, witnessed people manufacturing and using hashish. Hashish, this is a mixture of tobacco and marijuana. This has to do with marijuana. You know what the number one cash crop in Kentucky is? Marijuana. It used to be tobacco, it's marijuana, and it has been for a long time, but not with everybody. I guess you got a whole bunch of people raising marijuana all across America now. So this case seems almost stupid in some respects. Medical marijuana is legal in Kentucky, but marijuana has been legalized completely all across a whole bunch, 25 states or so. And marijuana clearly isn't crack, it's not cocaine, it's not meth, it's not fentanyl, it's none of those, it's not even hard, it's not even alcohol. You think it's okay to drink alcohol, but you're against marijuana, you're a hypocritical pile of shit. Native Americans used to have the peace pipe. The Native Americans used to have the peace pipe. So you got this Paul Branzburg, where the namesake comes from. Paul Branzburg had wrote 2 articles concerning drug use in Kentucky. The first had featured unidentified hands holding the hashish, the tobacco/marijuana mixture, while the second included marijuana users as sources. So he had 2 articles, one with a picture of the illegal substance, and then the second article talked about the marijuana users, quoting them, what they thought, what they said. These sources requested to not be identified. Both of the articles were brought to the attention of law enforcement personnel. Branzburg was subpoenaed before a grand jury for both of the articles. He was ordered to name his sources. I remember this one guy, Joe Young. He said that there were a bunch of illegal activity, a bunch of illegal gaming that was happening in Sanders, or what was it? I think it was Sanders or Glencoe. And then I said, well, how do you know about that? And he says, oh, I'm not going to reveal my sources. I don't care about your sources. I just want to know if the damn thing was true or not. That's all I cared about. So that actually wouldn't matter. If I'm a judge and I bring Joe Young in, he would have to tell me how he knew that happened. Now, both of the articles were brought to the attention of law enforcement personnel. Branzburg was subpoenaed before a grand jury for both of the articles. He was ordered to name his sources. Paul Branzburg refused to go to the grand jury hearing. He is like, nope, I got freedom of the press privilege, and therefore I'm not going to go. And then he got held in contempt. While evidentiary privileges have been recognized since as early as the 2nd century AD, and well-established privileges exist for attorney-client, psychotherapist and patient, clergy and penitent, and spousal communications, a modern movement is underway to provide an evidentiary privilege for yet another set of communications, those between journalists and their sources. So you want to investigate crimes, you want to get to the bottom of things, but you also got to respect people's freedoms, right? So for an attorney talking to their client, if the client had told the attorney that he's just doing a whole bunch of drugs and selling a whole bunch of marijuana, if the Branzburg had told his therapist, or if he had told his priest, or if he told his wife, he could just claim privilege. No, I got husband-wife privilege. I got clergy penitent privilege. No, I got psychotherapist, patient, attorney-client privilege. But he was not allowed to say freedom of the press, which is incredible because that's the First Amendment. There's something to be said about this. A great and reusable quote from the 1972 Branzburg v. Hayes case is this: although the powers of the grand jury are not unlimited and are subject to the supervision of a judge, the long-standing principle that the public has a right to every man's evidence, except for those persons protected by a constitutional, common law, or statutory privilege, see U.S. v. Byron and Blackmer v. U.S. 1932, is particularly applicable to grand jury proceedings. So the public has a right to every man's evidence. Where's that come from? 1972, Branzburg v. Hayes. The public has a right to every man's evidence. And so if you call, a Greenie, right? If you say, hey, Greenie, you need to come in. If you say, hey, Soto Cruz, you need to come in. Hey, Susie Lucero, you need to come in and tell us the evidence that you have. Well, they have to come in and they have to give their evidence. Either they witnessed something, they saw the documents, they know something. The public has a right to every man's evidence. That's important for a criminal investigation. Some people, when it comes to what were the privileges, attorney-client, psychotherapist, clergy penitent, spousal communications, can you just say, I don't feel like it? Can you just lie to the judge? Hey, judge, I'm your friend. Don't let this happen to me. Is there a judge corruption? Is there a judge corruption privilege? Let's see here. Judge corruption privilege. No, I'm not seeing any judge corruption privileges. So, Soto Cruz, he is friends with Troy Zinn, and because Troy Zinn is a right-wing sovereign, well, they're going to protect the right-wing Nazis in Colorado. You see the shit that's happening in Aurora, and you see the shit that's happening in Springfield. The fucking governor does not give a shit about crimes. If the police don't do shit about it, and the courts don't do shit about it, and then you defend yourself, and a cop thinks you did something wrong, well, they're just going to fuck you the fuck over. So that's the most important part. That's the whole reason I'm doing all of this. 1972, Branzburg v. Hayes says that the public has a right to every man's evidence. Now, the journalist privilege gained notoriety from the highly publicized incarceration of former New York Times reporter Judith Miller when she refused to comply with a court order compelling disclosure of the source who revealed the covert CIA agent Valerie Plame's identity. She went to jail for this. She says, no, I will not identify my source. I believe in freedom of the press. And the First Amendment, the Second Amendment, adjudicated like a motherfucker. The Third Amendment, we barely even talked about the Third Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment. And there's freedoms past the 8 amendments. There's 9, 10, 11, 12. It goes all the way to 27. You got the preamble and the body. You got freedoms in the preamble. You got freedoms in the body of the Constitution. And you got freedoms in the amendments 1 through 27. We haven't even figured out how the freedom of the press works. 1972 Branzburg v. Hayes furthermore says that the court then reaffirmed prior Massachusetts holding that testimonial privileges were exceptional and limited, stating that the principle that the public has a right to every man's evidence had usually been preferred in the Commonwealth to countervailing interest. So the public has a right to every man's evidence. And to be honest, if we're going to crack down on crime, then we should give a shit about case law, federal case law, even our civil liberties. We should understand our civil liberties. It should be clear, cut, and dry. What we are allowed to do and what we're not allowed to do. So you're allowed to say what you want to say. You're allowed to write what you want to write. You can publish what you want to publish. But if the grand jury calls you in, or if you're subpoenaed for any other court case, the public has a right to every man's evidence. So that goes up against the First Amendment. But what about if you're not even claiming the First Amendment privilege? Hey, I'm a cop. I can just do as the fuck as I please. I'm above the damn law. No, that's not good enough. So Soto Cruz has to go in and he has to testify everything that he knows. And then Susie Lucero has to go and testify everything she knows. Phil Greeny, he had a photograph. He pretended he was a government agent. So he has knowledge. And then 4 eyewitnesses. So if you want to sit there and say, I defended myself. If you want to sit there and say, some other shit happened besides me defending myself, that Joe Canty had threatened my life, my property, at my home. The home, so he threatened my life, my property, my dogs, while I was at home. And then he's going to lie on top of this shit. He was being a piece of shit. And he threatened to murder me. He threatened to murder my dogs. He threatened to drive over my fence and maybe even into my home. He jerked his steering wheel. Well, you say, well, why would he just do that? People don't just do that. Because I told him to get the hell out of here. He was driving slow as shit. My dog started veering towards him. So I told him to get the hell out of here. And then he jerks his steering wheel. He's driving a big rig. Some of you Sean Grayson fans want to say a pot of water. Oh my God, she had a pot of water. Oh, that's a deadly weapon? A pot of water that could cause serious bodily injury? Then clearly a car. You got vehicular homicide. Clearly a car can be a deadly weapon. And then if a car can be a deadly weapon, then a big rig, which is twice as big as a damn car, could be a deadly weapon as well. But instead, we're going to try to take a liar's lie and shove it down the people's throat. Why? Because they're a bunch of fucking assholes. This is a police state, a totalitarian police state. They don't give a damn about right or wrong. They don't give a damn about the truth. And you certainly can't get no justice if you don't know the truth. The public has a right to every man's evidence. The public has a right to every man's evidence. So, Michael's saying that Susie Lucero and Soto Cruz and Phil Greeny didn't have to show up. They didn't have to come in. That was a crime. The public has a right to every man's evidence. And then there was Robert Pickerel. Where is he? And then there was I think it was Noah Spalding that was over there in the corner. And then Phil Greeny's aunt. They're all part of the series of events. Do you want to get to the bottom of things? Do you want to find out the truth? Oh, well, you were kidnapped. You were kidnapped, so we got to keep on fucking you over. Nah, the body was kidnapped. The body was taken, so now you get to rape that body forever and ever. I hope Michael Gonzalez doesn't work in a morgue. Anytime they get a body for him, he'll just rape the shit out of it. I mean, clearly, the person is guilty. Clearly, all the probable cause, all the threshold, all the things that they needed, you kidnapped the body. You got the body right there. I'm so sick of the police state fucking totalitarian bullshit. The three branches don't know jack shit. So when a cop does a fucking thing, everybody seems to get in line and just says, oh, great fucking job there, copper. Alright, well, let's see you get up on the stand and testify. Oh, you're not going to because you're a criminal piece of shit and you had a fucking bias and you're prejudiced? Oh, Soto Cruz is a prejudiced piece of shit who defends the criminals. That's why Michael Gonzalez isn't going to call him up to the stand. That's why Susie Lucero is not going to be called to the stand. She lied, said she wasn't properly subpoenaed. She was properly subpoenaed. I had a fucking process server. Had to read the fucking laws, get the process server, hand her the fucking... And it wasn't even against her. But hey, I'm a government person and I don't have to do my damn duty. I'm a government person and I'm just here to fuck people over. She knows that I was the only one paying for planning and zoning permits and nobody else did. So you think that the person who committed the crime is the one that called 911, paid for their planning and zoning permits? Meanwhile, Robert Pickerel said, fuck your permits, fuck you, Michael. And then so did Phil Greeny, fuck you, Ann Kelly. They all said, fuck the courts, fuck the truth, fuck justice. And that's who they all fucking defend. Why? Well, you got the body. So you get to just rape the shit. I hope none of these assholes work in a fucking morgue, bunch of wannabe necrophiliac motherfuckers. (1972) Branzburg v. Hayes cites 1950 U.S. v. Byron case. Now this is more interesting. So this is more quotes because it goes on and explains what they mean. So the full quote from 1950 U.S. v. Bryan case says this: certain exemptions from attending or having attended given testimony are recognized by all courts, but every such exemption is grounded in a substantial individual interest which has been found through centuries of experience to outweigh the public interest in the search for truth. Dean Wigmore stated the proposition thus: for more than 3 centuries, it has now been recognized as a fundamental maxim that the public, in the words sanctioned by Lord Hardwicke, has a right to every man's evidence. When we come to examine the various claims of exemption, we start with the primary assumption that there is a general duty to give what testimony one is capable of giving, and that any exemptions which may exist are distinctly exceptional, being so many derogations from a positive general rule. Of course that's the fucking case. Of course that's the case. You want us to stop crimes. If the cops don't do their damn jobs and the courts don't do their damn jobs, then we get a right to stop it ourselves. You just want us to be victims of crimes and just be, thank you, ma'am, wham, bam, thank you, ma'am, here's $1. Stupid motherfuckers. Footnote 7. So 1950 U.S. v. Byron explains, U.S. v. Bryan explains, B-R-Y-A-N. Why does the public have a right to every man's evidence? Because, in general, you want what the testimony, you want to know the truth, so you want to know what testimonies are out there. You want to know what the documents say, you want to know what the eyewitnesses say. There are claims of exemption, right? There are some privileged relationships. You also got the right to remain silent. If you think that you committed crimes, then you could say you plead the fifth. If you don't have one of those recognized privileges, then we need for you to tell us what the fuck you saw. Why would you not tell us what the fuck you saw? Why would you be a goddamn criminal piece of... Oh, I see. If you don't know the Fifth Amendment privilege, then you would just say, fuck Michael Gonzalez and Ann Kelly and the court system and the cops, because you don't know what the fuck is going on and you know you're a criminal piece of shit. And it'll be obvious when you're sitting on the stand that you're a criminal piece of shit. You have to lie some more, and then hell, if you get caught in a lie, well, that's perjury. And then if you lose your temper, well, hell, that's contempt. No wonder Michael fucking cheated. No wonder he's a corrupt fucking piece of shit, corrupt, covering up with Susie Lucero. One professional corruptionist is covering up for another professional corruptionist is covering up for another professional corruptionist. And they're covering up for the criminals who's covering up for the criminals who's covering up for the criminals. Am I the only person out here against crime? Am I the only person out here against crime? He called 911. He must be the one who did it. That's a great way to lower the crime rate. Just arrest the victim. Then you would have, well, hell, nobody reported any crimes. Well, then what happened? There's all this property destroyed and there's all this blood everywhere. Well, we didn't have to charge anybody of anything. We arrested the victim, we told them to shut their mouth, and then they went home and they said, what the hell? 1972 Branzburg v. Hayes was a certiorari to the Court of Appeals of Kentucky. What exactly does certiorari mean? Certiorari. All of these Latin terms, people want to be like, well, you didn't do the certiorari. It's a writ or order by which a higher court reviews a decision of a lower court. Okay, so you went ahead and reviewed the lower court, and then the higher court. All right, so there you go. A higher court reviews the lower court. It's also an opinion. I thought it was just an opinion. But apparently it's a little bit more than that. Well, you're reviewing the case and then you're offering the opinion of what you think about that case. Because the grand jury's task is to inquire into the existence of possible criminal conduct and to return only well-founded indictments, its investigative powers are necessarily broad. Branzburg, quoting Blair v. U.S. of 1919, the grand jury is a grand inquest, a body with powers of investigation and inquisition, the scope of whose inquiries are not to be limited narrowly by questions of propriety or forecast of the probable result of the investigation, or by doubts whether any particular individual will be found properly subject to an accusation of crime. Let's read the Fifth Amendment. What does the Fifth Amendment say? The Fifth Amendment says, you're a bunch of fucking assholes. Okay, not exactly. That's not exactly what the Bill of Rights says. Well, I don't have the bill. Well, here I do. Okay, hold on. I'll carry on with this. So we already quoted Blair v. U.S. of 1919. We also had, what was that, 1950 case. What was that 1950 case? U.S. v. Bryan. And all this is 1972 Branzburg v. Hayes. Who's Hayes? Who the Hayes gives a shit? Why don't you go to Hayes? You go to Hades. Hayes. Okay, so the prevailing constitutional view of the newsman's privilege is very much rooted in the ancient role of the grand jury that has the dual function of determining if there is probable cause to believe that a crime has been committed and of protecting citizens against unfounded criminal prosecutions. Well, that's both good and bad. I've once heard the quote that the grand jury is both the sword and the shield. Let's write that down. Grand jury is both the sword and the shield. So the grand jury can investigate, and they have broad investigative powers. They can bring anybody in, ask whatever questions that they want to ask. Until you get a grand jury indictment, you can't go to the petite jury, and therefore you can't get a conviction. So it's the sword because it can issue the indictment. It's the shield because when they investigate and they find out, oh, well, this shit, they don't have any evidence. You got a lying piece of shit who perjured himself over and over again. He's just saying this. He could just be saying it. He has no corroborating evidence. He's got no videotape. He's got no photographs. He's also a liar. So that's clearly not enough evidence to proceed. No probable cause. No probable cause has happened. Article 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now there's an exception. This is the Fifth Amendment. A lot of people say, I plead the Fifth. You do have a right to remain silent. But you have other freedoms in the Fifth Amendment too. You also have the double jeopardy clause. You also have the due process clause. You can't be deprived of life, liberty, or property without due process. You also have the eminent domain clause. But the very first clause of the Fifth Amendment is this. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So the rule is you got to have a grand jury indictment. You can't put a felony on somebody until you have got a grand jury indictment. You just had that shooter in Georgia, and that judge knew that he has to get a grand jury indictment. Unless you want to waive that, he doesn't want to waive that. You go get the grand jury indictment. There's plenty of fucking evidence that that goddamn Colt Gray fucking shot those kids. You got the videotapes. You got a whole bunch of eyewitnesses. You got tons and tons of evidence. Get the probable cause. Get the grand jury indictment. Now you can put a felony charge on Colt Gray. And maybe Colin, and then maybe his mother. They all seem to be criminal sons of bitches. So you have a right to a grand jury indictment before a felony charge can be put upon you. Now there's exceptions. The rule is you have a right to a grand jury indictment. But in cases where the land or naval forces, so if it's in the military, in the Navy, in the Air Force, or in the militia, we used to have militia all over the place. Now it's just a bunch of crazy right-wingers. We should have more left-wing militias. We need a rainbow militia. When in actual service in time of war or public danger. So if you're in war, well, have to get the fucking grand jury together. Okay, it's a little cumbersome. But if you're not in a wartime and there's no public danger, there's a big fire blazing, hey, wait a second, you need you probably can make the arrest. You know, if there's public danger or war, I think you still should be able to get the grand jury indictment, but those are the exceptions. So the rule is, you have a right to a grand jury indictment. You have a right to a grand jury indictment, except during war or public danger. When it comes to the land and naval forces, which there's military law, so it's almost like a whole separate subset. Military law is completely different. And then in wartime, everything is different. And public danger, everything, it was an emergency. We had to do the thing because it was an emergency. If nobody's in the Army or the Navy or the Air Force and the militia, then none of that even matters. The exceptions don't matter. You have a right to a grand jury indictment. The grand jury is both the sword and the shield. And how exciting would it be to be a part of the grand jury or the petite jury? You're asked to take a part into your republic. The damn judge just wants to fuck that person over. The damn prosecutor wants to get a whole bunch of prosecution so she can brag about how awesome of a piece of shit she is and then get reelected by all of her rich folks. But if you're a part of the petite jury, you can actually look at the evidence and then you can be the one holdout. They got to get a unanimous jury note. So if you say you don't think that person is guilty, then that person won't be convicted. And part of the grand jury proceeding, you take 23 people. You take 23 people and you can do a presentment. So you can be the one that initiates the proceedings because you saw the crime. And then if you're part of the 23, all you need is 12. When you get 12 to say that the person, say Alec Baldwin, they think there's probable cause, then it goes to the next step. It goes to the petite jury. Or the grand jury thinks that there's 34 felonies of Donald or the hush money case or the classified documents or the January 6th. And what's great about that is here in America, you can't get a felony charge put upon you unless you get 12 of your peers from the grand jury plus 12 of your peers from a petite jury. Unless 24 of your own countrymen say that you committed the crime, that you committed the felony, you can't get a felony put upon you. How exciting. What a great free country. This is a free country with a bunch of free people. We all know the preamble. We all know the Constitution. We all know our rights. It's so great to be part of such an informed culture. Blair v. U.S. 1919. The grand jury is a grand inquest, a body with powers of investigation and inquisition, the scope of whose inquiries is not to be limited narrowly by questions of propriety or forecast, I already read that, of the probable result of the investigation or by doubts whether any particular individual will be found properly subject to an accusation of crime. Because the grand jury's task is to inquire into the existence of possible criminal conduct and to return only well-founded indictments, its investigative powers are necessarily broad. In a way, it is kind of, what is this, the Inquisition? Yeah, it is. It's the grand jury. The prosecutor had to get 23 of regular citizens out of their chairs into the courtroom to look at this matter, that matter, and do you know of any crimes? And that's beautiful. You just have one piece of shit cop wants to fuck over another person, and then one piece of shit judge and one piece of shit prosecutor. You only need 3 people to fuck a person over if we live in a police state. But if you're part of the grand jury, then you can say, oh, I think this was happening, or I saw this, or I was actually a victim of a crime. And then you get to be a part of the grand jury and look at other people's accusations and worries. Grand jury proceedings are constitutionally mandated for the institution of federal criminal prosecutions for capital or other serious crimes, and its constitutional prerogatives are rooted in long centuries of Anglo-American history. Anglo being English. Hannah v. Larchey, 1960. Frankfurter J. concurring in result. What is 1960 Hannah v. Larchey about? Who gives a shit? So, the Fifth Amendment, we've already explained. You can't be held to a capital or otherwise infamous crime. Why do I keep saying felony? Well, capital is if you're being confronted with the death penalty. Infamous crime, well, we've already talked about infamous crime. The courts have talked about it, and it has to do with the length of incarceration. If you're going to be incarcerated, put in jail for 1 year or more, which is in terms of the federal government, that's a felony. all the felonies have at least 1 year in jail. So for every felony, especially from the federal government, you may have to look at your state constitution. I know that Colorado says that you have to have a grand jury indictment before you can put a felony on somebody. The adoption of the grand jury in our Constitution as the sole method for preferring charges in serious criminal cases shows the high place it held as an instrument of justice. Costello v. U.S. 1956. And people are like, what is a grand jury? We don't even understand. Costello v. U.S. 1956 says that, why did we put it in the Constitution? That's the sole method for preferring charges when it comes to serious criminal cases. Shows the high place it held as an instrument of justice. He was jaywalking. I'm going to accuse him of felony murder because I'm a corrupt cop piece of shit. You just saw Tyreek Hill. But Your Honor, he was shooting at us. No, he wasn't. You lying piece of shit. Take it to the grand jury. You have 12 of your grand jury and plus 12 of the petite jury, then a felony can happen. But just some corrupt fucking cop and corrupt prosecutor, corrupt judge, all you take is 3 people to fuck a person over. That's a police state. That's a totalitarian police state. There's no 3 branches of government. There's no freedoms. There's no rights. And the truth, apparently, nobody gives a fuck about the truth. But Alec Baldwin could shoot and kill Helena Hutchins. Everybody's fine with that. I mean, he got the bag of bullets, right? Some ex-Arizona cop dropped the bag of bullets. All right, I'm just going to read the rest of it. The rest of this is a whole bunch more quotes that comes from Branzburg v. Hayes. Branzburg v. Hayes. I'm going to read straight through. You ready? Here we go. Although state systems of criminal procedure differ greatly among themselves, the grand jury is similarly guaranteed by many state constitutions and plays an important role in fair and effective law enforcement in the overwhelming majority of the states because its task is to inquire into the existence of possible criminal conduct and to return only well-founded indictments. Its investigative powers are necessarily broad. It is a grand inquest, a body with powers of investigation and inquisition, the scope of whose inquiries is not to be limited narrowly by questions of propriety or forecast of the probable result of the investigation or by doubts whether any particular individual will be found properly subject to an accusation of crime. Blair v. U.S. 1919. Hence, the grand jury's authority to subpoena witnesses is not only historic, id. at 279-281, but essential to its task. Historically, the grand jury has been regarded as a primary security to the innocent against hasty, malicious, and oppressive persecution. It serves the invaluable function in our society of standing between the accuser and the accused to determine whether a charge is founded upon reason or was dictated by an intimidating power or by malice and personal ill will. Well, if that ain't goddamn Soto Cruz, Susie Lucero, and fucking Michael Gonzalez and Ann Kelly to a fucking T, hey, you assholes should read Wood v. Georgia, 1962, Wood v. Georgia. Malicious assholes, personal ill will, trying to be fucking intimidated. Hey, I got a badge. Yeah, I can turn a lie into a truth. It has been held that infamous punishments include confinement at hard labor, U.S. v. Moreland, 1922, incarceration in a penitentiary, Mackin v. U.S., 1886, and imprisonment for more than a year, Barkman v. Sanford, CA 5, certiorari denied, 1947. There's also Greenberg or Green. There's another case that went to the Supreme Court. Anything more than a year, imprisonment. Federal Rule Criminal Procedure 7A. So the rules of criminal procedure, the federal rules of criminal procedure 7A has codified these holdings. An offense which may be punished by death shall be prosecuted by indictment. An offense which may be punished by imprisonment for a term exceeding 1 year or at hard labor shall be prosecuted by indictment, or if indictment is waived, it may be prosecuted by information. Any other offense may be prosecuted by indictment or by information. Although indictment by grand jury is not part of the due process of law guaranteed to state criminal defendants by the 14th Amendment, Hurtado v. California, 1884, a recent study reveals that 32 states require that certain kinds of criminal prosecutions be initiated by indictment. Spain, the grand jury passed the in the 18 states in which the prosecutor may proceed by information, The grand jury is retained as an alternative means of invoking the criminal process and as an investigative tool. Jeremy Bentham, then it lists a whole bunch of them here. Does it say? No, it doesn't say. But it does. It is in the Constitution. In the U.S. v. Burr, Chief Justice Marshall sitting on circuit opined that in proper circumstances a subpoena could be issued to the President of the United States. A number of states have provided newsmen a statutory privilege of varying breadth, but the majority have not done so, and none has been provided by federal statute. Until now, the only testimonial privilege for unofficial witnesses that is rooted in the federal Constitution is the Fifth Amendment privilege against compelled self-incrimination. We are asked to create another by interpreting the First Amendment to grant newsmen a testimonial privilege that other citizens do not enjoy. This we decline to do. Fair and effective law enforcement aimed at providing security for the person and property of the individual is a fundamental function of government, and the grand jury plays an important constitutionally mandated role in this process. On the records now before us, we perceive no basis for holding that the public interest in law enforcement and ensuring effective grand jury proceedings is insufficient to override the consequential but uncertain burden on news gathering that is said to result from insisting that reporters, like other citizens, respond to relevant questions put to them in the course of a valid grand jury investigation or criminal trial. Thus far, 17 states have provided some type of statutory protection to a newsman's confidential sources. Alabama, Alaska, Arizona, Arkansas, California, they put it in their law, in their criminal code, that you must have, that the press, I'm mixing up cases. All these states I'm about to name say that you do have a right to freedom of the press, and if a grand jury or a petite jury calls you up, you don't have to testify. So that's cool, right? But not cool. You got the First Amendment, but then you got this fucking Supreme Court case that actually says, no, you don't have it. So, hey, I read the law. If you read Alabama law and you said, hell, I could be a press, I could be a newspaper reporter, I could be a citizen journalist. You interview a bunch of people and then they drag you into court. And you say, well, hell, I just read Alabama law. They'll say, well, no, actually, you don't interpret the law. We interpret the law. But I read what it said. It said, you know, this and that. Here's what the Kentucky law says. Well, first I'm going to name all the states. They're saying it doesn't fucking matter. They're saying it doesn't matter. It doesn't matter if you read the First Amendment. It doesn't matter if you read your state criminal code and it protects your right to keep your source confidential. It doesn't matter. Branzburg v. Hayes, 1972 is pretty much a shitty decision, but it does show how important that the public has a right to every man's evidence. It is very important for us to stop crime, and if we're going to stop crime, we need to investigate the crime, and if we're going to investigate the crime, then we need to be able to talk to anybody and everybody. We need to find out what documents you know, what you didn't know, what you did know. Now, if you have an honest man, and the honest man has power, now imagine if Soto Cruz goes out there and he actually interviewed the people that I had accused, and he asked them tough questions. If he actually investigated it, he would have found out the truth. So Alabama, Alaska, Arizona, Arkansas, California, Indiana, Kentucky, Louisiana, Maryland, Michigan, Montana, Nevada, New Mexico, New Jersey, New York, Ohio, Pennsylvania, all these have specific laws on the books that say not only do you have the First Amendment right to freedom of the press, but you also have a right to keep your sources confidential. Here's how the law reads for Kentucky, KRS 421.100. No person shall be compelled to disclose in any legal proceeding or trial before the court or before any grand or petite jury or before the presiding officer of any tribunal or his agents or agents or his agent or agents or before the General Assembly or in any committee thereof or before any city or county legislative body or in any committee thereof or elsewhere, the source of any information procured or obtained by him and published in a newspaper or by a radio or television broadcasting station by which he is engaged or employed or with which he is connected. I just thought of a reason why you wouldn't want that. There is that one guy who was lying in the New York Times, and he was saying he was protecting his sources. You had to catch him in a damn lie because you're not allowed to ask him who his sources are. Oh, I quoted this guy. A lot of times you'll say a White House official. You'll read that in these newspaper writings. Well, they could just be making it up. And since they don't have to say who their source is, I feel like I would see that there's a balancing test. And if it's like a fucking murder case, a rape case, a fucking mass, murder case, or stealing a whole bunch of stuff, or stealing a car, attacking, assaults, if it's a big ass torture, maim, slavery, if it's like a big crime, then you should not be protecting that source. But smoking marijuana, get the fuck out of here. Get the fuck out of here. Branzburg v. Hayes. I got like 5 more paragraphs. This cannot go over an hour. Okay, good, it won't. So more information, the writ of certiorari